Hello, my name is Lee O'Reilly and this is DUI 101. Today we're going to talk about expungement, record clearance, and termination of probation. Let's start off by defining our terms. We'll start with termination of probation. If you've been convicted of a DUI, then the chances are very high that you are on probation for 3 years or alternatively for 5 years. The vast majority of all DUIs, especially first offense DUIs, are 3 years. Now, for that 3 years that you're on probation, if you submit any kind of a job application, they're going to see that you're on probation. I had a client who got a job at Safeway in the meat department, and he was only there for about 4 hours when he was told to turn in his apron because they discovered he was on probation. One of the problems with being on probation is that a lot of background checks don't tell you why you're on probation. The other thing is, in this economy, where there are 30 people applying for every job, if there's anything that sets you out in the negative, and a criminal record will do that, you can forget about your job. It got so bad that in the first year of President Obama's administration, when they sent out these stimulus funds, some of the funds were used in Santa Clara County to terminate probation and expunge the record of first offense DUIs so that these people could get back into the job market. What do you need to clear your record? First of all, what does record clearance accomplish? What happens with record clearance is if your sentence is expunged, the court reopens your case. So you can honestly answer after your record has been expunged that you've never been convicted of any crime. The most you would have to admit is that you were accused of a crime, but then the record was later dismissed. And that's how I would handle it if I was applying for a county job or a job with any kind of governmental agency. What do you need to get your record expunged? Well, first of all, you can't have any other crimes on your record after your DUI conviction. And you certainly can't have another DUI. So the DUI conviction has to be your own misdemeanor. Second, you have to have paid all your fines, you have to have completed DUI school, and you have to have completed your probation effectively. Okay. And third, of course, you had to have been convicted of a misdemeanor and not a felony. We'll talk about that a little later. What if you want to apply to have your record expunged before your probation has terminated? We do this all the time. We bring a motion for termination of probation, and then we couple it with a request to expunge the sentence afterwards. And the courts are pretty willing to do that, if you have the facts behind you. What you want to do is you want to submit a declaration to the court, and you want to show the consequences of having this criminal record on your personal life. Any deleterious consequences that you can think of. The best ones always have to do with employment, particularly in this economy. So if you can submit a statement to the court to the effect that you've made 5 applications for jobs, you were told by 2 of them that that you weren't being considered because you were on probation, or they didn't hire people with criminal records. And as long as the job application that you were submitting didn't have anything to do with driving or any rational connection between the DUI and the job that you're applying for, that's a pretty compelling reason. A client of mine was trying to find work, and he talked about the fact that he was invited to submit an application, he was accepted for employment, and then 3 hours later he got a call without explanation saying that sorry, they couldn't give him the job after all. That's a pretty good indicator that background check pretty much took care of that guy's chances. So when you go in with a declaration like that, it really helps. Where are you going to find the law for record expungement? You're going to look under 1203.4 of the Penal Code, and it'll lay it all out. Now, what about those who have been convicted of a felony? Well, the felony that most DUIs are concerned with is 23-153 of the Vehicle Code. That's getting in an accident where there were injuries to some person other than the person who was driving under the influence. So if a person who's driving DUI gets into an accident and injures other people, 23-153 is called a wobbler. It's a crime that can be charged as either a felony or a misdemeanor. If you're charged on a wobbler and you're convicted of a felony, but your sentence doesn't involve going to prison, if you do your sentence in county jail, okay, then what you do is you go in on a motion to set aside the conviction in the interest of justice. And an attorney can do that for you. And basically, I think it's going to depend on the facts, and it's going to depend on everything that you've done to make sure this crime doesn't occur, plus the declaration of need as to why it is you need to get this. Then what they do is they reduce the crime from a felony to a misdemeanor, and then they dismiss the misdemeanor. So if you're charged with a wobbler and you don't go to prison, then that's how you're going to get your record cleaned up. If you do go to prison, if you're charged with a felony and you do time in prison, you're going to need a certificate of rehabilitation. A certificate of rehabilitation involves filing a motion with the court, just the same as when you would terminate probation or expunge your record in relation to a misdemeanor conviction. You file a motion with the court. If it's granted, then it goes to the governor's office. And the governor has a board that basically handles pardons. And they will consider it. I've got one certificate of rehabilitation right now. We filed it and we had it granted by the court about 3 months ago. And we just checked yesterday, and the governor's office told us that they were finally opening the file and beginning to work on it. Expect the whole certificate of rehabilitation process to take about 6 months. How long will it take for an expungement? Well, if you're coupling the motion for an expungement with a request to terminate probation, in other words, you're applying for an expungement before termination of probation has been completed, before probation is ended, you're going to have to notify the probation department and give them an opportunity to show up at your court hearing. They will oppose it. They always do. Don't take it personally. It's just what they do. And it rarely has that much of an effect on your application for expungement, but sometimes it can. It depends on what their reasons are.